Ladies and gentlemen, I had prepared a somewhat longer presentation, but in view of the time, I'll cut it as short as I can and focus on the matter of the constitutional complaint as a democratic tool for the development of constitutional justice only from the Bulgarian perspective. Because, regretfully, what is true for Bulgaria is also, to a large extent, true for many of the new democracies in Europe. The acting Bulgarian constitution of 1991, for the first time in the country's history, provided for a constitutional court as a special body to exercise concentrated constitutional control. The mere establishment of a constitutional court testifies to the new quality of the state as democratic and committed to the rule of law. Over the years, the Bulgarian Constitutional Court has established itself as the pillar of the fundamental rights and freedoms of the citizens. However, in the context of the growing influence of global constitutionalism, it now faces a number of challenges of a new generation. The most significant democratic tool to meet these challenges is the individual constitutional complaint. At present, the access to constitutional justice in Bulgaria is reserved for holders or intermediaries of public authority. This is a situation that hinders the unleashing of the potential which the Bulgarian Constitutional Court undoubtedly has. The hindered access of citizens to the court negatively reflects both on the court's public image and the public trust and doubt on it. Without a doubt, this situation defies logic. It is precisely the citizens whose rights the constitutional justice has been primarily intended to protect, and those citizens do not have access to it in one way or another. Regretfully, such an idea does not have a political endorsement in our country. The comfort of having the monopoly on referring to the Constitutional Court is not something that will be given up easily. A constitutional court accessible to citizens under one form or another would gain new opportunities, would acquire a power independent of the politicians. It would become an ally of the people against unconstitutional but politically convenient legislation. The political class seldom gives up power without serious pressure. The palliative constitutional revisions in the recent years have increased the circle of subjects who can turn to the Constitutional Court. Apart from the President, 1/5 of the members of Parliament, the Council of Ministers, the Prosecutor General, and the two Supreme Courts, now the Ombudsman and the Supreme Bar Council have been vested this right. This, however, proved to be insufficient. Overall, the idea of mediators between the citizens and the Constitutional Court is an unconvincing one. The possibility of introducing an individual constitutional complaint has been widely discussed in the socio-political and academic circles. To justify a low beneficial effect of the private constitutional complaint, opponents of this institute point to a low percentage of successful complaints in comparative perspective. My understanding is that the quantitative indicators are not as important as the qualitative characteristics of the institute, measurable through the protection of the constitutionally guaranteed rights of the individual. In general, incorporating the constitutional complaint into the national mechanisms for safeguarding the fundamental rights is in itself a testament to a higher legal culture of both the society and the political class. The concern that the constitutional complaint would significantly hamper and disproportionately burden the work of the court is ungrounded. The review of the possible solutions in other countries shows that the flow of complaints can be filtered by setting strict admissibility requirements and procedures. It will undoubtedly be difficult for the court, but in none of the countries that I know of, the comfort of judges is more important than the rights of the people. What has been said so far, in my view, convinces that there are less and less conceptual arguments to support the absence in the Bulgarian legal order of the straight path by which the citizens could reach the Constitutional Court. This is why I believe the time is ripe for the debate about the future of the Bulgarian constitutionalism to enter into a new stage, where the emphasis is put not so much on whether the constitutional complaint should be incorporated in the general constitutional model of Bulgarian state, but on its type. The pointer in the forthcoming in-depth discussion will undoubtedly be about the scope of the complaint. whether to introduce a normative constitutional complaint, which would allow the citizens to attack legal norms that served as a basis of acts of the public power, or a full constitutional complaint, putting in its reach also the act of the judiciary and the executive. Driven by conceptual and pragmatic considerations, I support the incorporation in the legal order of the Republic of Bulgaria of a normative constitutional complaint. Let me repeat again. It is unreasonable for the state to have as powerful a tool to protect citizens' rights as the direct constitutional complaint, and at the same time deny the citizens access to it. As the Bulgarian model of constitutional justice is built on the idea of control over norms, the adoption of the normative constitutional complaint would fit best in the current regime. This will help avoid the risk of the Constitutional Court turning into a fourth instance and will safeguard against the possible imbalance between the traditional and the constitutional justice. I finish my report with the message that started it. The state owes legal protection to every person in order to make use of their fundamental rights. Therefore, the citizens' need for wider individual legal protection is always fair and justifiable from a constitutional point of view. I am convinced it is a matter of time and political will, which so far is lacking, unfortunately, to strike the right balance between empowering citizens with yet another democratic instrument to protect their constitutional rights and maintaining legal certainty on the other hand. In search of the balance between those two essential components of the state committed to the rule of law, we can always draw from the experience of other European states. The mere setting up of the Constitutional Court with the 1991 Constitution marks the clear transition from a communist to a democratic society. The introduction of the private constitutional complaint will be a proof that this tradition is irreversible. Thank you.
Admirable how you managed to condense a long speech into a few minutes, but I think we should take one question if there is one. Yes?
Sure.
I wanted to ask, I know that in trying to develop democracy over the years all over the world, we always have a problem with the constitution and the implementation.
True.
But now throughout the world we are facing a serious problem of corruption. It's all pervasive, locally, nationally, and globally. Would you recommend that we establish in the various nation states anti-corruption courts to sort of do the same kind of thing that constitutional courts have been doing within their sphere?
Well, it is strange that you should ask me that because I'm also a former prosecutor general of Bulgaria. And I have this experience of teaching my students criminal law for about 30 years. Yes, there is such a court in Bulgaria. There is a specialized criminal court dedicated only to fighting corruption-related crime. Whether it's a good idea or just, let's say, just a forum to show the political will to fight corruption is very hard to say. The results have been so far somewhat unconvincing. But I think that corruption is a phenomenon that is not so new or so modern or so different from what we know about corruption in the past. The ordinary courts, the general courts, are as qualified to deal with corruption crimes as they're quite qualified to deal with any other type of crime. Specialized courts dedicated on corruption only may look good politically, may be a proof of the political will to fight corruption, but I don't think that they have produced the results to justify their existence, at least so far.
Thank you very much.
Thank you.